everyone. My name is Paula Shapiro, and I'm the Associate Section Director of the American Bar Association's Section of Civil Rights and Social Justice. Welcome to the latest webinar of the Section's Rapid Response Project. A major priority of this year's Section Chair, Rob Weiner, is to respond promptly to actions of the administration that impact civil rights, civil liberties, and social justice. The Section accomplishes this by offering free webinars, commentary, podcasts, social media posts, and other information from subject matter experts. We'll be tweeting from our Twitter handle at ABA_CRSJ, posting on our Facebook page, and regularly updating our website, www.americanbar.org/CRSJ, with relevant news, webinars, and other projects. Our recent webinars on the Graham-Cassidy proposal and on Hurricane Maria and its aftermath are available on our Section's website. Our legal expert and moderator today is Mara Gendel-Powers. She is Senior Counsel for Health and Reproductive Rights at the National Women's Law Center. During law school, Ms. Gendel-Powers was a law clerk for Senator Al Franken on the Senate Committee on the Judiciary, Subcommittee on Privacy, Technology, and the Law. She brings with her a wealth of knowledge from past positions with the Children's Health Advocacy Project and the Association of Maternal and Child Health Programs. Mara?
Hi, thanks everyone. Just want to make sure you can hear me.
Yes.
Okay, great. Okay, so I really want to thank everyone for joining us today. We have a great panel of experts who are going to be talking about the latest rulemaking on the Affordable Care Act, birth control benefit, and the implications for women's health. We are joined today by Madeline Gomez, who's a legal fellow at the Center for Reproductive Rights. She joined the center in 2016, and she assists with all of the aspects of the center's U.S. litigation. She first worked there in 2013 as a legal intern, but she most recently came to the center from the National Latina Institute for Reproductive Health, where she was an If, When, How Reproductive Justice Federal Policy Fellow. And we are also joined by Beth Parker, who is Chief Legal Counsel of Planned Parenthood Affiliates of California, the statewide entity that coordinates the legal, legislative, advocacy, regulatory, and electoral work for Planned Parenthood's 7 California affiliates. And combined, the California affiliates operate 115 health centers and provide 1.6 million patient visits each year. And I think what's important to think about how we're addressing this today is that we're going to think about, you know, these rules that came out, but also how things are playing out in all different branches of the government and how lawyers are involved in all different spaces in that. But first, sort of to set the ground, I think it's important to know what this benefit meant for folks before these rules came out. That's how you truly can understand the scope and impact of the rules. So under the Affordable Care Act, birth control is supposed to be covered without out-of-pocket costs for all enrollees who need it in health plans. And when this was put into place, the Obama administration created a very narrow exemption for churches and houses of worship. And there was an accommodation, what was known as an accommodation, put in place for other religiously affiliated employers, particularly nonprofits. So think about hospitals, universities that may be religiously affiliated and object to birth control coverage. And under that accommodation, the employer or university's plan would exclude birth control coverage, but a third party would step in and pay for birth control coverage for the individuals in the plan who needed it. So if you were in a plan that had an accommodation, it really should look and feel just like you worked for any other employer who didn't have an objection. What the new Trump rules that were released on October 6th did was basically to drive a Mack truck through that exemption. So they both broadened it in terms of what kind of objection you could have. So there was one rule that came out that said you could have a religious objection, and another one that added a new moral objection to birth control that folks could claim. And the other way it broadened it was by expanding the entities that could be eligible. So previously, as I said, it was a narrow exemption for churches and other houses of worship. Now, virtually any employer can say that they have a religious or moral objection to birth control. Under the religious rule, it is any nonprofit, any for-profit, any non-governmental employer could say that they have a religious objection to birth control. Under the moral objections, it is any nonprofit and any for-profit that does not have parts of its ownership publicly traded. But they, as we will get into, are taking comments as to whether that should be expanded. So it really is very dramatic, and we are very concerned about what will happen to folks, particularly those who were in plans that had the accommodation, and now their employers who objected before and voiced their objections before will go into the exemption, and they will have no coverage. Their birth control will not be treated as health care anymore. They will have to pay entirely out of pocket, so it's not just going back to copays or deductibles. They have no coverage for birth control. And so I think there are a couple things to think about. The administrative response, these came out as interim final rules, so there is an opportunity to comment even though they are already in effect. The comment period is through December 5th, and I really, we will talk more about ways you can get involved, but I would really encourage folks to comment if this is something that you care about. And there have been legislative responses. At the federal level, last week we saw bills introduced in both the House and the Senate to rescind these rules, which is a really good step, although I think we, being realistic about this Congress, we don't think those bills are necessarily going to go anywhere. And states have already, and Beth will talk about a little bit about the California experience, but states have already taken some steps to protect some people and their insurance coverage. State law does not reach every person with employer insurance coverage. There are some employer plans that are only regulated by the federal government, and so there will be folks where state laws don't reach them. So it is important to think about how the federal benefit in the ACA really set that floor for coverage that people have come to expect over the last several years. So we've also seen responses in the courts. And first, I'm going to turn it to Madeline, who can tell us about the suit that her organization, the Center for Reproductive Rights, filed, I believe it was last week.
Yeah. Great, thank you. And I do just want to take a second and say we forgot to mention that you can ask questions of the panel that we will get to at the end. So there's a chat box. I think it should be to the right of your screen. But you can actually type in your questions, and we will take those at the end. So getting back to litigation, on October 10th, on Tuesday, on behalf of Medical Students for Choice and a number of individual students at the University of Notre Dame, the Center for Reproductive Rights, along with our co-counsel at O'Melveny and Myers and the Yale Law School Program for the Study of Reproductive Justice, filed suit against the Trump administration. We named the Acting Secretary of HHS, along with the Secretaries of the Department of Labor and the Department of Treasury as defendants. And our suit was filed in the District Court for the District of Columbia. A number of other cases have also been filed throughout the country, as Mara said. So state attorneys general in Washington, Pennsylvania, Massachusetts, and California, which Beth will discuss in more depth, have all filed suit against the Trump administration. And additionally, the ACLU has sued in the Northern District of California on behalf of its members and the SEIU, United Healthcare Workers West. And then finally, actually, an individual suit was brought by a teacher in Denver, Colorado last week. So generally speaking, most of these suits have substantially similar claims. There are a couple of small differences, but just for ease, I'm going to talk about the center's challenge to the interim final rules. So we've brought challenges under the Administrative Procedure Act and under the Constitution. So our APA claims are both procedural and substantive. As Mara explained, these are interim final rules which totally bypass the notice and comment period. The APA lays out very specific circumstances under which an agency may enact such a bypass. But here, the agencies have absolutely failed to meet those requirements for any such exception. And so we are arguing that that's a violation of the APA. And then substantively, the rules violate the APA in three ways. First, they're arbitrary and capricious. The second is that they reverse agency policy without a reasoned explanation. And the third is they exceed the department's statutory authority. So getting back to the arbitrary and capricious and the reversal of agency policy, previously with the accommodation that Mara discussed, the agencies had struck a very deliberate and careful balance between They are interested in providing comprehensive, seamless, no-cost coverage in service of public health and women's equality, frankly, and then balancing that with the religious beliefs of certain institutions and employers. These rules totally abandon that balance, and they also completely upend it. They place the full and significant weight of the burden of these employers' religious beliefs upon innocent third parties, their students and employees. And they do so without any statutory authority. There is no statute that grants the departments the authority to so dramatically expand the exemption. And in fact, this agency action runs contrary to statutory law that the departments are charged with implementing, including the Affordable Care Act. We also have 3 constitutional claims. The first is the Establishment Clause. So the Constitution prohibits the government from creating religious exemptions to neutral, generally applicable rules that result in significant burdens on third parties. But by shifting both the financial and sort of myriad other costs of contraception and access to that care onto the intended beneficiaries of the contraceptive coverage requirement, who are, of course, women, and many of whom do not share the religious beliefs of their employers, the agencies impose significant burdens on women, and in doing so, don't accommodate religion. They actually are establishing a particular religious belief. And then our second constitutional claim is equal protection, which is fairly straightforward. These rules discriminate on the basis of sex by allowing institutions to refuse to offer coverage for contraceptives, which is a service used only by women. And furthermore, in doing so, the rules perpetuate gender stereotypes about women's role in society. And then third, and this claim is unique to the center's complaint, we are arguing that the rules violate the fundamental right to liberty and reproductive freedom, which includes access to contraceptive services without undue interference from the government. By allowing institutions to erect significant barriers to services, they infringe on this fundamental right. So that's the center's complaint, and like I said, the other complaints that have been filed nationwide are seeking a few other claims here and there, but generally speaking, we are all seeing a lot of overlap. And the center has not yet moved for a preliminary injunction. In fact, we haven't seen anyone ask for that yet, but we expect that some folks will.
Thank you so much. That was a very concise discussion of what is, in fact, a lot of claims that I have seen in your complaint. So thank you so much, Madeline. So several states' attorney general have also filed suit against the administration. And Beth, you have been working closely with the California Attorney General. And so I think it would be great if you can tell us a little bit about what we should know about California and other states' lawsuits.
Sure. I wanted to give some background on this first because I think it will help folks to understand the claim. First, we believe that about 13 million women in California benefited from the contraceptive mandate under the Affordable Care Act. But despite that, we have worked to pass legislation in California to ensure that those women would continue to be protected in the event the administration did something like we're seeing today. So in 2014, our legislature passed the Contraceptive Coverage Equity Act, and this requires private health insurers and Medi-Cal to cover contraception, those methods that are approved by the FDA, at no cost. In other words, patients similar to under the Affordable Care Act would not have to have copays. So this covers all of Medi-Cal beneficiaries in California, which is about 13 million, or a third of our state. And it also covers plans that are regulated by either our Department of Managed Healthcare or Department of Insurance. Those are the two agencies that regulate insurance in California. Significantly, it does not cover self-funded plans. And as Mara said at the beginning, self-funded plans are not regulated by state laws, but instead by the federal government under ERISA. So state law does not protect that class of employees. And we anticipate that there are about 6.8 million people in California who participate in self-funded plans. And before I describe that, I just want to say we believe there are about 27 other states that have also enacted similar contraceptive equity laws, and we can probably talk about that in a moment. In any event, in California, we think that about 6.8 million women are potentially impacted by these rule changes. There are 250 employers that use self-funded plans. 26 of them are religiously affiliated, and they employ about 53,000 people. But we don't know if any of the other large employers will also avail themselves of these exemptions. And these are huge. They range from major healthcare organizations that are Catholic, such as Dignity Health, lots of other religious institutions, such as the Roman Catholic Church, and major employers ranging from United Airlines to Costco, Ford Motor Company, DuPont, Home Depot, Macy's and Nordstrom's, Walt Disney Company, Target. I think you get the picture. A lot of major employers have chosen to self-fund their health insurance, and therefore they get out from under the regulatory arm of the state governments. And they could all choose, if they wanted to avail themselves of these rule changes. So the state of California, through the Attorney General, filed a lawsuit. As Madeline said, it too has similar claims: violation of the Administrative Procedure Act, violation of the Establishment Clause of the First Amendment, and violation of the Equal Protection Clause of the Fifth Amendment. And as she explained, I think very succinctly, the claims are basically the same, that what the federal government has done here has not provided any notice, opportunity to comment, evidence-based expert guidance, and acted arbitrarily and capriciously. And because it is really favoring religious institutions over employers and the ability for employees to access birth control, that it's a violation of the Establishment Clause and that it discriminates against women. And the harm that we're seeing and that we're arguing about in California is twofold, and I wanted to explain that. The first harm is that women will now be forced to access government-funded programs for contraceptive care. And in fact, in the IFRs themselves, the government actually gave this as a reason. It said because there are all these government-funded programs for contraception, employers could opt out because women will have other access. This is ironic because separately, the federal administration is trying to defund both Planned Parenthood, which is a major provider of contraceptive care, as well as programs like Title X, which provide contraceptive care for low-income beneficiaries across the country. So it's very ironic that at one point they're saying, oh no, we can let employers off the hook, the government can do it, while at the other hand, they are simultaneously trying to defund all of those programs. But give that as it may, what this is doing is shifting the cost of providing contraceptive coverage from employers of the private sector to the government, in other words, taxpayers. And the way this works is, in California, we have a wonderful program called Family Pact. It's been in existence for about 25 years, and it provides contraceptive care to anyone who is 200% or less of the federal poverty line, which for a family of one is about $24,000. And that care is provided 90% by the federal government and 10% by the state, except for certain categories of people, in which case it's paid for 100% by the state. So the argument is that women who will no longer get contraception through the plans paid for by their employer will then become FPAC patients at added cost to the state. And this is especially true for younger patients, many of whom obviously access contraceptive care, because if they're no longer able to get insurance through their parents and their parents' insurance plan, they will come to clinics such as Planned Parenthood and be eligible for Family Pact. And indeed, about 47% of our patients in California are age 25 or less. And for each Family Pact patient, the average cost of a visit is about $333, of which $75 of that the state of California pays. So if patients who no longer have access to their employer's health insurance need to now go and become members of Family Pact, the state will have to absorb that care at considerable cost. The second harm to the state of California is that if women no longer are able to access birth control, undoubtedly we will see a huge increase in unintended pregnancies and most likely abortion. Because if you're not eligible for Family Pact or birth control, the chances of you getting pregnant greatly increase. We know from research that those who do not use contraception, the rate of unintended pregnancy is about 45%. And in California, 64%, and I know I'm using a lot of statistics, but 64% of births are paid for by our state. So if there's an increase in unintended pregnancy, the costs for delivery, miscarriage management, and abortion all go up significantly. It's estimated that for each added unintended pregnancy, it costs the state over $15,000. And the costs are not limited to these. You also see increased costs for social programs for those women and their children. You have increased prenatal costs, increased maternal mortality, and the like. And one of our state agencies recently estimated that the cost of unintended pregnancies in California exceeded $689 million. So the gist of the argument is really that if employers are no longer shouldering the cost of contraception and can easily get out of it, that women will either avail themselves of government-funded programs or run the risk and most likely get pregnant, and all of that will greatly increase the costs to the state.
Thank you so much, Beth. That was, as you said, a lot of statistics, but that really is the root of why this matters to the state of California, is the impact and the cost on folks who are living there and what this will mean in their real lives and for the state's programs. So I think all of this discussion of litigation is probably ringing bells for a few people, and they're maybe thinking to themselves, wasn't this all dealt with in Hobby Lobby? Didn't we go through this already? Wasn't there a case at the Supreme Court? So can you all put these cases in context with Hobby Lobby, which is maybe what folks have heard of before? Madeline, maybe I'll start with you.
Sure, yeah. So, you know, I always think about that great line from Justice Ginsburg in Hobby Lobby where she says she was concerned the court was venturing into a minefield, and now we really find ourselves just smack in the middle of that minefield. So Hobby Lobby did two things that are relevant here. First, under the Religious Freedom Restoration Act, it extended the accommodation to closely held for-profit corporations who were otherwise not included within the accommodation or the exemptions under the ACA. And that decision, at least in part, opened the door to this kind of line of reasoning that we're seeing now in the rules that you know, any company or institution that has religious or moral objections should just be able to kind of weigh themselves out of it. But second, and really importantly, like I said, Hobby Lobby extended the accommodation. So it made clear, the court there, that the accommodation sufficiently accounts for the religious concerns of institutions, and that, like I said, it strikes a careful balance between the government's interest in women's equality and public health and access to contraceptive care and these claimed religious beliefs. So, I mean, I find the Hobby Lobby decision to be very frustrating on many levels, but it importantly, and I think, you know, really carefully, made sure that employees still have access to no copay, seamless contraception, that it's part of their broader insurance coverage. It didn't leave them sort of hanging out there with no coverage at all. And these rules ignore that. They fly in the face of the court's reasoning and its decision, and are really leaving employees sort of open to the whims of their employers or institutions. And I think, as Beth so just poignantly pointed out, that's millions of women throughout the United States who could be impacted by the rules.
Thanks. Beth, is there anything you want to add on what Madeline said about Hobby Lobby?
No, I think she nailed it, which is these rules go way beyond the decision in Hobby Lobby, because in addition to greatly broadening the exemptions, they also pretty much eliminate the accommodation that was at the core of the Hobby Lobby decision.
Yeah, and the Hobby Lobby cases were followed shortly thereafter by challenges from nonprofit organizations that then claimed that even the accommodation violated their rights under RFRA. And those were known as the Zubik line of cases. And they got, I think, a little less press coverage than the Hobby Lobby case. They ultimately made their way up to the Supreme Court. And interestingly, the Supreme Court did not issue a decision in that case. They issued an order sending the cases back down to the circuit courts and essentially saying, we think the parties can figure it out. They did that in May of 2016. And what the rules that came out on October 6th do, and they very explicitly say this, is part of their intent is to finish having to deal with that litigation. And that is one of the rationales that they used for doing it without notice and comment, doing an IFR. Obviously, all of the folks on this call are involved in litigation and see that these rules are just creating more litigation, but that is part of what the rationale was in the rules. And also, I think folks are probably aware of this. These rules are not happening in isolation. There are currently, as we talked about, they're talking about cutting Medicaid, Title X, and those are things that they say are backups for women who don't have birth control coverage through their employers. But at the same time, there are a lot of issues around religion and the folks' ability to use religion as they see in their business. These rules came out after the president signed an executive order on religious freedom in May, and that executive order did explicitly say that HHS, Treasury, and Labor, who issued these rules, should reconsider the contraceptive coverage and preventive services benefit. So, I think we see that this is connecting with other communities and other fights that are currently going on in the civil rights world. So, Madeline, I'm wondering whether you could talk a little bit about the infringement on civil rights that we see here and connecting to other communities.
Yeah, so, you make a really great point that the Trump administration has been speaking quite a lot about religious liberty. I think it's important, first of all, to talk about what religion we mean when we say that. Of course, the administration is taking a very different tact when it talks about people of Muslim faith or from majority Muslim nations. So we're really talking about Christianity in particular. But on the question of religious freedom, I also want to point out that this nation actually has, these rules and all of the talk of religious liberty is, like you say, happening in a broader context. We have a long history of sort of contextual deference to religion as a means of justifying discrimination. Similar tactics and arguments were being made historically in defense of racial discrimination. And they're rearing their head again today, as in these cases when it comes to access to contraceptive care, reproductive rights, but we're also seeing it in a lot of the LGBTQ movement, in reactions to the LGBTQ movement. So in cases like Masterpiece Cake Shop, which questions whether business owners should be allowed to refuse service to customers simply because of the customer's sexual orientation or desire to use a service kind of in a wedding between a same-sex couple, for example. So that's one piece. The other thing that I think is really important to highlight is the newer line of argument we're seeing in this conversation about religious liberty is this idea of complicity, which is a sort of attenuated facilitation, and how that is somehow a burden. So I think there's been a lot of press recently about the ACLU's case in this DC circuit of Jane Doe, who's an immigrant 17-year-old girl seeking an abortion. And in that case, the federal government is arguing that by temporarily releasing her, they would somehow be facilitating an abortion. And it sort of becomes this meaningless distinction. But the arguments for religious justification really are becoming so much more tenuous and several steps removed. And that poses a huge threat to civil rights, of course, because then any movement towards progress could potentially be claimed as some kind of burden.
Yeah, I think those connections are really, really important to be making. And Beth, I know you all probably, Planned Parenthood is fantastic at serving a variety of communities particularly LGBTQ folks. And so I'm curious what you're, if you all are hearing things on the ground with people who are concerned about these kinds of refusals that are happening.
Yeah, we're obviously very concerned both from an LGBT perspective, but we're very concerned actually from the immigrant perspective. One of the things that we've been quite worried about are, similar to what we're talking about, the intersection between these different movements, are concerns with ICE raids at our health centers. In previous administrations, there had been an agreement not to do ICE raids at hospitals, community clinics, courthouses, houses of worship, and that guidance was lifted. And there's a lot of concern within the community that we're going to see those again at our health centers. We do serve in California a very large percent of undocumented patients. A lot of our staff comes from those communities. They reflect those communities, and so it's just really created this huge amount of fear amongst a population that really desperately needs our healthcare services.
Yeah. So I feel like we've painted a pretty bleak picture, and I know folks are probably well aware that things are challenging right now. But so hopefully you're sitting there thinking, what can I do to help? What is the next step? I think the really, the very obvious next step on these rules is to submit comments, right? I think people have gotten very accustomed in the last several months, I'd say 6 to 9 months, with calling their members of Congress, but weighing in on the administrative branch through rulemaking and writing comments is a very important step, and I think that's something that folks can do. From my perspective, I'm thinking about if you work at an employer or folks who work at businesses, those businesses should come out and say, we publicly commit to covering birth control, right? So, this is a no-brainer for most businesses, and it's good for business to say, this is what we provide to our employees. And I think folks need to know that this is the norm, right? Here at the Law Center, we also have a legal network for gender equity that we recently launched, and you go to our website, nwlc.org. You can find out more about that, ways that folks who are in private practice can fight sex discrimination. And I know Beth and Madeline have other thoughts in terms of responses, so I'm going to turn it over to Madeline first.
Sure. So absolutely, there's also the ability to comment through the Center for Reproductive Rights website. So we are at reproductiverights.org. Right on our homepage, there is a link to adding your comments. And additionally, we have a program called the Lawyers Network, which helps to put attorneys in conversation with one another, and we help them to facilitate different programming, generally, of course, in service to reproductive rights. And again, there's more information about that on our website and how you can get involved to try to sort of drum up support for reproductive rights activism and support in your community.
I just want to mention that the comments are due December 5th. I don't know if that was mentioned, but people should submit their comments. I think the general thought in our communities is that the more comments, the better. We really want to be establishing that this is just not acceptable. And we're all happy. I think all of us are doing comments. We're all happy to give templates and provide help on that, so just reach out. And then I want to reiterate what Mara said about finding out whether your employer is self-funded or not. As I rattled off, a lot of major corporations in the United States actually are self-funded, some of the largest, and then really try to get them to come out publicly and say, we intend to continue to provide coverage for birth control for our employees. I wholeheartedly agree this is a win-win for everyone. Employers really want and need their women employees. It's better for them if women are able to space their pregnancies or space between their children, all of which is what contraception allows. We've seen huge inroads for women as a result of the legalization of contraception since 1965. And we don't want these rights to go away. But I think it's really a win-win. And I think if a lot of major corporations come out and say, we're going to continue to provide birth control coverage, it's going to show the Trump administration that it's just not acceptable to deny women this type of health care.
Thanks. So that does bring us to the end of our planned, what we wanted to talk about today. We already have at least one question in the question box, so I want to flag for folks that if you have questions about any part of what we were talking about, how this might look where you live or what you can do, please feel free to use the question and answer function. So I'm going to go to our first question, but please, folks, do write in. And I think this one might be best, you might be best positioned to answer this, but how much does a full month's supply of oral contraception cost for one woman without any insurance or government discounts? And maybe you could also talk a little bit about all the other different methods of birth control that are now out there, and how much that, maybe not all, not everyone, but there are 18 methods that have to be covered under the ACA's birth control benefit, and they range in price and reasons why different women want them. So maybe you can touch a bit on that.
Yeah, I actually don't know what a full month supply of pills is. The issue with birth control, and as Mara said, there is a really big range. We go everything from pills to Depo, which is a shot, to implants. Implants, what we call long-acting reversible contraception, or LARCs, are the most effective, but they're also the most expensive. They're typically between, I think, $500 and $700 for to have the implant. So that's obviously very expensive, particularly for younger women before they start working. And many, the state of California, the state of Colorado, I think the state of Oregon, many states actually are really encouraging long-acting contraceptives because of their effectiveness overall. One of the issues that we're seeing is with this administration, and where we have real concerns, is a tax on another program called 340B, which has been in place for decades and allows safety net providers such as Planned Parenthood to purchase drugs at significantly reduced costs. So a pack of pills just costs a couple of dollars, and then we get reimbursed. I think in California we get reimbursed for $12, but it allows us to provide contraception to large numbers of the safety net population at not significant costs to the state, which is paying for it. If the 340B program goes away, which, as I mentioned, we're very concerned about, those costs are going to skyrocket, and it will make it much more expensive for community clinics and Planned Parenthood to continue to provide contraception, and that's going to exacerbate all of the problems that we're talking about right now.
Yeah, and I would add, in my abbreviated description of how this ended up in part of the ACA, the birth control benefit, the way it worked was that an expert panel of women's health experts came together, and they were tasked with figuring out what preventive services for women are not currently covered under other sets of preventive services. And one of the things that they looked at, and should be covered, right? And one of the things that they looked at were studies saying that when women face out-of-pocket costs for preventive services, they are much less likely to get those. And those can be what seem to us maybe to be really small out-of-pocket costs. Even $6 can keep someone from going to get their preventive service. And when you think about it, it's for someone who's really, even someone who's living paycheck to paycheck and living, a middle-class life, but paycheck to paycheck, $6 or $10 or $15 can really add up. And if you have to decide between, going to take your child to the doctor and getting your prescription, you're probably going to take your kid. If you have to decide between paying the gas bill or the water bill and getting your prescription, those are really tough decisions. And that's not just for folks who are, in programs like Medicaid. Those are tough questions for folks who get employer coverage too. And so that is one of the reasons why this was included, is because those out-of-pocket costs can be real. In terms of the out-of-pocket costs for oral contraception without any insurance or government coverage, there are dozens of different formulations on the market, which is a huge advance for women because I think, as most folks who've been on, particularly the birth control pill know, there are different kinds of synthetic hormones that are in them, or additional ingredients, and people can have different reactions. So once someone finds the right pill that works with their body the best, they like to stick with it. And pills, generic pills can be very, seemingly inexpensive, $5 or $6 without coverage, or they could be $150 a month without coverage. Personally, for me, when I was in law school, I had no prescription drug coverage, and I paid $75 a month for my birth control because I knew it was the one that worked for me. And that was a huge expense. That was a real expense in my life, but I had to make it work. But that is where things are for some folks, is that it's that much a month. So.
Can I add one thing to all of that, which is another thing which is really critical is the seamless access to birth control, because historically people would go in, you get a month or 2 months, but then if you got busy or you didn't have the funds, you might skip. And anytime you skip birth control, that increases your odds of having an unintended pregnancy. So what's really been key is wanting to have this seamless access. And one of the things we did this year in California is we passed legislation requiring 12 months of birth control, that insurers have to provide 12 months. And a big study that one of our state agencies did said that was going to save an enormous amount of money at every single level, because of ensuring that women were always going to have their birth control on hand. So I just wanted to point that out, that this really starts interfering with that goal, which is good for women, it's good for their employers, it's good for our society as a whole.
Mm-hmm. Yeah, and that, I think, like you were saying, in terms of society as a whole, one of the things that the panel of women's health experts looked at was, preventing unintended pregnancy with the ultimate outcome of improving birth outcomes. Intended pregnancies have better birth outcomes. There are much lower costs. When you have a better birth outcome, you're not looking at NICU costs necessarily, which can be astronomical at times. So I think that's something that folks need to be taking the whole picture of what birth control really means in women's lives. So it's health of the children, if folks choose to have children, it's the health of those children. But it's also, so important for women to be able to plan and space their pregnancies so that they can finish school, they can, get the job that they want, they can go for the promotion, and time when to have a family if that's the right choice for them. So I just want to put a flag out there. If you have other questions, it would be great to have those come through the question and answer box. Just looking to see if anything else came through.
Mara, there are two. One is there any concern that many large employers announcing that they will not stop covering contraception will allow the administration to argue that the rule will not change employer behavior or impact many women?
That's a good question. Madeline, I see you thinking.
I'm sorry, Beth, could you just repeat that really quick for me?
Is there any concern that many large employers announcing that they will not stop covering contraception will allow the administration to argue that the rule will not change employer behavior or impact many women? I think one thing I will say is it depends on what you say is the impact, because as I mentioned, in California, we believe that there are 25 religious employers that will take advantage of this at a minimum, and that is about 53,000 employees, which I would consider to be money.
Yeah, I mean, I think too, I would say our case has students from Notre Dame. Notre Dame has been very active in challenging the accommodation. They've actually brought litigation a couple of times. And so even if one large employer, I mean, Notre Dame is a large university that, of course, educates a lot of students, but also employs quite a lot of people. And I think any burden on those students is too much. So I think these rules are very clear that they had particular institutions and employers in mind when they were crafted. I don't think that you need to have every single employer who could take the exemption do so in order to show a significant harm. Yeah,
and I think what's important to note there too is that you know, from our perspective, whether it was 5 women who were impacted or 5 million women who were impacted, this really does trample on their ability to get the coverage that is required under the law. And not, you know, these are not the way this has been done is not in a way that's appropriate under the APA, but also the actual substantive content of these regulations is unconstitutional. So I think that's important, whether it's 5 women or 5 million or 15 million. The next question that came through is the religious beliefs of the company would still override the employee's health needs even if the birth control is not needed as a contraceptive but needed as a hormone control. And what's very interesting about this rule, in fact, is that I think they thought they were doing something good in clarifying this, but I think it makes them look even more callous, is that they make it very clear that if you need birth control for purposes other than preventing pregnancy, the ACA's birth control benefit does not apply to you. So if you need it to manage bleeding or to manage acne or to deal with anything else that is related to things that birth control deals with, this birth control benefit entirely, not just the exemption and accommodation, doesn't apply to you. So your plan could cover it with copays and with a deductible, and that's clarified in this rule. I think that probably was the case before this rule, but it was not explicitly in the regulatory language or in the preamble, I think. But this rule made that very clear. So I think it is. I don't think it has the intended effect of what they intended when they drafted it. But Madeline and Beth, I'd love to hear your thoughts on that too.
Beth, you want to go ahead?
Yeah, I don't really have anything to add to that.
No, I think you hit it, Mara. The only other thing that I would say is that it's a little bit of a fiction, right, to pretend that women are sort of disengaging one use from the other. I mean, of course, there are some women who do not need it for contraceptive coverage for whatever reason, but I think generally speaking, you use a medication for any number of issues, and it has any number of benefits. And so this idea that, like, today I'm using it to control my acne and tomorrow I'm going to use it to prevent pregnancy is just kind of farcical.
Exactly. Yeah. The data is out there. It shows it. Most people use it for multiple reasons, and that can change over a lifetime. What those are.
Nobody's business.
So I just want to encourage, if anyone else has questions, please type them into the question box. Paula, can I hand it back over to you then?
Yeah, thank you so much, Mara, Beth, and Madeline, for answering our questions and for giving us this overview on what is happening right now. We're really appreciative of your time. And if you have any closing remarks, we would love that. And while you give your closing remarks, if there's any other questions from people who are watching, please feel free.
Beth, I'll hand it over to you first.
I think the most important thing is we're just at the beginning, obviously, of the litigation. As Madeline said, no one yet has filed for a preliminary injunction, but I think a number of the parties are planning to. So I think in the coming weeks, we're going to see how the courts will start dealing with these issues, and undoubtedly these will go up and potentially even get up to the U.S. Supreme Court, because there were a lot of unanswered questions as a result of the Hobby Lobby and Zubik line of cases. But I think most importantly is for people to really engage on this subject, to let people know what's happening at the administration. This is not going to be the first, nor it is not going to be the last attempt to undermine women's rights to access contraceptive care in addition to abortion. We really need to be speaking out as our communities, both by submitting comments to the administration, but much more publicly, and getting your employers to speak up on your behalf, I think is really crucial in this next period of time. So thank you all.
Yeah, I mean, I would just echo everything that Beth said, and in addition, reiterate that this is just one more in a long string of actions this administration has taken both against women's health and equality and against science. We have the data on our side. Contraception is critical to women's health care. It is health care in and of itself. If folks know people who are worried about losing coverage, I think in addition to getting engaged with the comment process, you should also get in touch with here at the Center for Reproductive Rights, at the National Women's Law Center, and other organizations. You know, it's really important that we speak out and really talk about what the employers are doing. So that's all. I just encourage you to be vocal.
And Madeline, we had a procedural question that came through that I wanted to pose to you. Won't the interim final rule cases likely become moot once the final rule is issued? Can you talk through the procedure a little?
Sure. Yeah, so I think that there are some questions about what that would do to our procedural claims under the APA, but the constitutional claims will remain the same and will not be moot. Obviously, there is significant harm that these rules will do to women, and our substantive APA claims will remain intact.
Exactly. It doesn't change the process that they use to do it. Any other questions coming through? Okay. I mean, I think for my part, I would say thanks, to Madeline and Beth. I think it should be, and hopefully is clear to folks that across the women's health community and across the reproductive rights community, we are all getting very active around this. We would love to see folks in the private bar getting vocal, getting involved, whether it's doing comments, whether it's your firm standing up and saying, we are continuing to cover birth control because it matters for our employees and their families, or whether it's, talking to friends who maybe work at affected employers and helping them understand what's going on and helping them feel confident to reach out to one of our organizations to see what they can do as someone who is affected by this rule or who is concerned that they may be. Right? So I think that would be the takeaways at the end of the day. But thank you so much, too, to the ABA for having us. I think it's really fantastic that there's such a focus on these rapid response issues. I know there are a lot of things going on right now, and everyone has their own lives as well, and these things are tough to tackle because sometimes it is very personal and it's tough to watch this happening to something particularly around the birth control benefit where we've seen so much positive things over the last 5 or 6 years. So with that, Paula, I'll turn it back over to you.
Great, and I just want to thank you again for your participation. And if people do have questions that they want, they can always email me. If you have any ideas about other rapid response projects that you'd like us to focus on, my email address is Paula, Paula, .Shapiro, SHAPIRO, @AmericanBar.org. Thanks again.